Democratic National Committee has sued the Trump administration and its Federal Election Commission because of Donald Trump's efforts to destroy its bipartisan and independent nature of the Federal Election Committee, putting the Democrats at a disadvantage since Donald Trump, by executive order, has declared that he, and he alone, along with his attorney general, have to make all of the interpretations of law for every agency, including the bipartisan one, the one that's been set up after Watergate to avoid corruption. Well, that's not going to work when the Democrats are before the Federal Election Commission. They have to have confidence that the group is bipartisan, that it's independent, that its 5 commissioners are voting independently and not being manipulated by Donald Trump. And they're listening to the counsel, not of Donald Trump and the Department of Justice, but of its own general counsel. That's the very structure that Congress set up. And congressional independent bipartisan commissions have been blessed for over 100 years by the United States Supreme Court. I've got the new complaint in my hand filed by the Mark Elias Law Group. I'm going to talk about it here. One place, Legal AF. Let's get to it. Now, this is not the first time ever that the Democrats have sued the Trump administration, except the last time was in the last administration when they sued over hacking the DNC emails and WikiLeaks. They tried to argue that that was some sort of election interference, and the DNC claimed that this was part of a larger effort to harm Hillary Clinton, and they sued the Trump administration over those released or about to be released emails. Now they filed their new case, and what they want is for the federal judge in the District of Columbia, we're waiting for him or her to be assigned, to find as a matter of law that the executive order, which is in play here, executive order 14215 subsection 7, which says that all federal agencies in the executive branch, regardless of their independence, regardless of how they were established by Congress, regardless of them being bipartisan, regardless of them having a statutory scheme that says they can't listen to the president, have to listen to the president in order for it to be for them to be compliant with his orders. Well, he just destroyed everything that Congress did after the last criminal presidency called Nixon and Watergate, trying to suck these agencies back into him, making it, at least in the political balance, in the political tug of war. We only have 2 parties in this country. I mean, let's be frank, Republican and Democrat. And the Democrats are like, wait a minute, hold. The umpire is now playing for the other team. The president is now going to tell the Federal Election Commission, which we rely on for being bipartisan, we rely on for being independent, we rely on in interpreting its own regulations pursuant to its own general counsel lawyer, is now taking direction from Donald Trump, the other party. We're screwed. And it violates the congressional law establishing in 1974 the Federal Election Commission, the Federal Election Commission Act, which we call FECA, and the rest of it. Let me read to you from the actual complaint and what they are seeking. They sue Pam Bondi, President Trump in his official capacity, Pam Bondi the same way, the Federal Election Commission, the commissioners, and the rest. Paragraph 4, for over 50 years, paragraph 1. In 1972, checks payable to President Nixon's re-election campaign were used to finance the burglary and wiretapping of the Democratic National Committee headquarters. The ensuing scandal resulted in a bipartisan recognition that federal campaign finance rules must be clean and fair, enforced neutrally without fear or favor. Those goals, Congress recognized, could best be achieved by conditioning the interpretation and enforcement of those rules on the consensus reached by members of an impartial oversight board. So they set up the Federal Election Committee. The fairness was by design. It's led by 6 commissioners, I said 5, appointed by the president, confirmed by the U.S. Senate. They act, at least 4 have to vote. The inherently bipartisan structure ensures that when political campaigns and party committees request rulemaking, seek advisory opinions on ambiguous statutory provisions, or defend against formal complaints, that they can be certain that the outcome will not be reflecting raw pursuit of electoral advantage by the political opponent. For over 50 years, paragraph 4, that certainty held. But on February 18th, President Trump issued Executive Order 14215, Section 7, saying that the president and the attorney general's opinions on questions of law are controlling on all employees in the conduct of their official duties, and prohibits any executive branch employee from advancing an interpretation of law as the position of the United States that contravenes the president or the attorney general's opinion on the law. In other words, he hijacked for himself and monopolized rulemaking and rule interpretation that Congress had given to an independent and bipartisan board. On paragraph 9, the complaint continues. Executive Order 14-215, which they seek to block, grounds its unprecedented assertion of presidential power in Article 2 of the U.S. Constitution, but the constitutionality of FECA, the Federal Election Commission's vesting of authority in the Federal Election Commission, is beyond question. It is an independent regulatory agency that Congress has always meant to be outside the clutches of a partisan White House. So here's what they ask for in paragraph 10 in the suit. The court, this district court, this trial court, should therefore certify the question of FECA's constitutionality to the en banc DC Circuit, meaning send it to the DC Circuit Court of Appeals, or actually to the entire, here's what they want. They don't even want one judge. They want this to go to the DC Circuit, right? I want to make sure I got the ask right. Yeah. They want this to go to the en banc circuit of the DC courts, the Court of Appeals, all the judges, to declare that the FECA provisions shielding their decision-making from presidential coercion and control are constitutional and valid, and enjoin the application of Section 7 of that executive order, meaning block it, as being inconsistent with those provisions. They then go through in the complaint all the ways historically since 1974 that commission was set up and all the requirements. For instance, in paragraph 30, they say the commissioners are also required to consider the views of the general counsel before voting on whether there is probable cause to believe a person has violated those rules. Commissioners cannot meaningfully consider the general counsel's recommendation if they're obligated to vote consistently with the diktats from the president, which makes perfect sense. They then talk about how the executive order monopolizes the authority to interpret FECA in the president and the attorney general alone, violates the independent structure of it all, and the like. Now, this is now up there. We get the wherefore clause here. The first count of the complaint, hot off the presses, action to construe the constitutionality of the Federal Election Commission Act. Count 2 is equitable relief for violations of the Federal Election Commission Act. And here's the prayer for relief, page 22 over to 23. Wherefore, the plaintiffs respectfully ask this trial court for the following relief. Declare that the provisions of FECA empowering the commissioners to exercise independent legal judgment, including but not limited to a series of laws, do not violate the U.S. Constitution, notwithstanding the executive order. Declare that the executive order section 7 is unlawful, as applied to the Federal Election Commission. Preliminarily and permanently enjoin defendants, that's Trump and Bondi and others, from applying that provision to the commission. Award them fees and costs. Grant relief other relief that may be proper. Sign Mark Elias Law Group. What's going to happen next? They are going to now, they asked for a speedy hearing. They've asked for injunctive relief. So we have yet another, chalk this up to suit number almost 100 here. We're going to have to see what judge has been assigned. Come right back here to Legal AF and the Legal AF podcast for an update. I think this is a winner for the Democratic National Committee. And I applaud, they have a new chairperson, Ken Martin for the Democrats. Now, there's a little bit of infighting about what do we do? How do we fight back? Who's going to take the lead? How do we stand in opposition to Donald Trump? I think we got our act together now. Ken Martin leading the way. Lawsuits like this filed on behalf of the Democratic Party. The Democrats in Congress using their ability to do cross-examination and questioning in congressional hearings, to do that, get those facts out into the public. Use those facts developed in Congress, in courts, in courtrooms around the country. Have the lawyers in the 100 or so cases have a clearinghouse to share information so that when something is filed by the Trump administration or a position is taken taken in one case, it ends up being used in another, because we know there's already inconsistencies where purposefully one hand doesn't know what the other hand is doing in the Trump administration, all on purpose for them to have plausible deniability. This agency doesn't know what this one's doing. This one says this is their responsibility. They don't know anything about it, and they go like this: I'm with him. And now, as courts are trained to do, they are starting to lock down the Trump administration, pin them down under oath with court orders for depositions and sworn statements and testimony under oath for hearings. There's already been about 50 hearings on temporary restraining orders, and hundreds of affidavits have been filed. So that's how the wheel turns. The wheel of justice turns slow, but grounds finely. And we're here for it, here on Legal AF. Until my next reporting, I'm Michael Popok. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event, by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states, and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok Firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok Firm, fighting for your justice every step of the way.